Good afternoon, everybody, and thank you for joining us. And apologise for the technical issue we were having. Sana had started presenting, and then we realised that people hadn't managed to get into the meeting. So apologies for that, and I'm glad everyone has managed to access the new link and is able to see us okay, and hopefully hear everything okay as well. So we'll just get started if that's okay. I am Claire Morrison. I am the Senior Manager of Policy and Sector Improvement at OSCR, and I'm delighted to be joined by colleagues from the ICO today, the Information Commissioner's Office, who are going to tell us a bit about data protection within charities. We will try and answer questions in the Q&A. We're happy for you to put questions in the Q&A as we go through the presentation, and we will try and answer them as we go along, or if they need to be answered by Sana, we will leave them till the end of the presentation. So once again, apologies for the slight delay and technical issues, but I'll now pass over to Sana, who will take you through the presentation.
Thank you so much, Claire. Hello, everyone. I'm hoping that you can now hear me. I had already run through a few slides before I got told that nobody could hear me, so sorry about that. Thank you so much for coming along. As I said, I'm Sana Gilfillan. I'm a Senior Policy Officer here at the Information Commissioner's Office. I actually used to work for a small charity before I joined the ICO, so I understand having a few resources and sometimes having to wear multiple hats. So appreciate you taking the time out to come and join us today for a little refresher or intro on data protection. And my hope with this presentation is to give you a high-level overview of what data protection legislation requires of your charity, and hopefully provide a framework for your compliance. So today I'm hoping to kind of go over what the purpose of data protection legislation is, what the aims are, go through a few basic definitions and principles and how they can be applied, and go through the rights that individuals have and what responsibilities organizations such as your charities have vis-a-vis those individuals, and how to uphold their rights. I will go a little bit into how we can use consent and be transparent. And I will also talk a little bit about direct marketing and how the rules around direct marketing have recently changed due to the Data Use and Access Act, which has recently come into force. And finally, I will talk a little bit about data breaches and how charities should look to handle data breaches. And we'll have time in the end, hopefully, for Q&A. So to kick things off, I think data protection can seem intimidating or maybe boring, but really it's about making sure that the processing of personal data is designed to serve humankind. I think a lot of the work that all of you do in your charities is already kind of set to do that and to benefit people. So the purpose of data protection legislation is just to make sure that when we're processing people's personal data, we are not directly or indirectly causing harm, and the framework that the legislation provides helps us to not unjustly infringe people's rights and freedoms. So that is the aim behind data protection legislation. So if we look at some of the basics around what is personal data. So under data protection legislation, a lot of different things can constitute personal data. It's any information that relates to an identified or identifiable living person who can be identified from that data. So it doesn't necessarily have to identify somebody by itself. It can be something that identifies somebody if you combine it with other information that, for example, is easily accessible. So examples of that might be names, ID numbers, location data, online identifiers. So going back to what I said, for example, if you have somebody's name, but by itself, you don't know which individual that's relating to, but then you have, for example, their address, that together does identify them, and therefore those things would be personal data. It also includes things like images or descriptions of people, expression of opinions about a specific person. What is not included under the GDPR or the regulation is processing of personal data that is done for domestic purposes, for purely personal or household activities. But if you, so nothing, so if there's no connection to professional or commercial activity, then that is out of scope of the GDPR. What is in scope is any processing of personal data that is wholly or partly done by automated means. So there's a digital element to it, or if it's purely done in the analog world, if it's part of a filing system or is intended to form part of a filing system, that brings it in scope of data protection legislation. So the data protection framework is built around controllers and processors. A controller is basically an organization that determines the purposes for which the data is processed. So in the context of your charity, you might be a controller for certain data processing activities. You might be a processor for other elements. A controller determines what the purposes and means for processing are, and therefore they shoulder the highest level of compliance responsibility under data protection legislation. They have to show that they're complying with all of the data protection principles as well as the other GDPR requirements, and they are the ones that are responsible for paying a data protection fee. Meanwhile, processors are organizations that are generally following the instructions from a controller, and so they do not have the same obligations as controllers, but they do have to follow the instructions of their controller, and they do have the obligation, for example, to notify their controllers of any data breaches so that the controllers can then fulfill any further notification obligations that they might have. So something that I think is probably of high relevance to a lot of charities is the distinction between just personal data and then special categories of data. So special category personal data is given special protection under the GDPR. This is because it can cause its misuse or loss can cause significant risks to individuals' fundamental rights and freedoms. There are 7 categories: race, ethnicity, political opinions, religious or philosophical beliefs, trade union membership, physical or mental health information, or genetic or biometric information, or information around sexual life or orientation. You might have noticed this doesn't include information about people's criminal records or criminal offense data. That is a separate category under data protection law. It has a separate set of requirements because it too obviously can have significant effects on individuals. And these are all they are all dealt with separately under data protection legislation. So while there might be other types of data as well that might be sensitive, for example, financial data, those are not considered special category data, though the requirements, the requirement to look after that data with a proportional level of security and accountability is still a part of data protection legislation. You still have to make sure that your processing is fair and meeting all of your requirements. One thing to note is that a lot of sometimes we've spoken to charities and there hasn't been an awareness that if you are processing special category data on a large scale, that you do have a requirement to have a data protection officer. So I just wanted to put that out there and mention it. And of course, if you are processing special category data and there's a data breach revolving these types of data, which is likely to have greater harms for individuals, that is something that we would consider when we are looking at taking any sort of enforcement action as well. So let's get into the data protection principles. So the first 6 of the 7 data protection principles are basically the building blocks required for overall compliance and the standard to which all data controllers should aspire. So that involves, the first one is to ensure that your processing is lawful, fair, and transparent, which basically means making sure that people know what you're doing with their personal data, and that might be through, for example, having a good privacy notice, and then it also means making sure you're relying on appropriate legal bases and conditions for processing where required. and that you are working within those parameters when you are processing personal data. The second one is purpose limitation, and that involves making sure that you're only using personal data for the lawful purposes that you initially identified, and that you're not using it for something completely different that people might not expect. And then the third is data minimization. This is the converse to that, which is that if you've identified a purpose, then you only collect or process the data that you need to fulfill that purpose. So kind of like, I guess, the Goldilocks principle, you don't want too much data, you don't want too little, you want just the right amount to fulfill the purpose that you had identified. The fourth one is accuracy, and this obviously means updating data as necessary and correcting where you have been alerted to any inaccuracies. And this is coming from the perspective of protecting individuals and making sure there's no negative impacts on them for having incorrect data about them be processed. So with this comes the responsibility as well, if you have passed on this data, if you've disclosed it to other organizations, to where possible also alert them of any corrections that you have been made aware of. The fifth one is storage limitation. We would recommend that you only keep personal data for as long as you need to fulfill the purpose. There might be other legal obligations or business need for keeping data for a certain amount of time. But generally, we would say you should think about limiting the retention of your data and deleting things that you no longer need, because it just makes it easier for you to fulfill the rest of the obligations laid out in these principles. So for example, it's easier from a security point of view, it's easier from the accuracy point of view if you don't have a whole bunch of records that you no longer need. Which brings us to the sixth principle, which is security, which also relates to confidentiality and integrity. So making sure you have appropriate internal measures to make sure that the data is held securely. This is not just a cybersecurity principle. It's around making sure that the data is accessible to you when you need it, that it's not able to be altered by people who shouldn't be able to alter it, that it's not accessible internally by people who don't really need to see it. So there's a lot to consider within that. And the seventh principle basically brings it all together and is the accountability principle, which means that controllers are the ones responsible for compliance with these six principles that we have seen here. So for processing to be lawful under the UK GDPR, you need to have identified and documented your lawful basis for the processing. So in your charity, you might be using personal data for a lot of different things, and each of those might have a different legal basis that you are relying on. The two most relevant ones may well be consent or legitimate interests. But there are 6 available legal bases, as you can see. And if you are processing special category data, then you also need a specific condition for processing. And that there's a whole list of them, so you might well fit into one of these categories. We'll go into a little bit what is, if you want to process special category data, for example, and you have relied on the legal basis of consent, you will also need a condition of processing, and that might be explicit consent. We will go into the distinction between that a little bit further down. But just to mention that if you're using, for example, legitimate interest, what does that mean? A legitimate interest basis for processing involves basically asking 3 questions, which is, first of all, do you have a legitimate interest in wanting to do this processing? Then is the processing that you have planned necessary to achieve that legitimate interest that you have identified? And finally, and perhaps the most important, have you balanced that interest that your organization has against the interest of the individual and the rights and freedoms of the individual? So if you can show that you're not infringing on the individual's interests or rights and freedoms, then you can probably use the legitimate interest basis. So it's worth talking a little bit about consent as well, because the UK GDPR and the data protection regime sets a very high standard for what is acceptable consent. And this is why you won't always use consent as your legal basis, because it might not be quite the right one to rely on. Consent, when we're using consent, means that individuals have genuine choice and control. So you can't use it as a precondition of service. You can't, have it be a lack of action that is considered consent. It has to be freely given. It can't be an imbalance of power, and it cannot be blanket. So you cannot say, for example, I am going to process your personal data to run my charity, for example. That would not be granular, that would not be specific. You have to identify exactly what you're doing with what data and get granular consent for that if that's what you're using. So in terms of explicit consent and the difference between consent and explicit consent is not, clearly defined, but in practice, it's not likely to be very different from the usual high standard of consent. So all consent has to be specific, informed, unambiguous indication of the individual's wishes. The key difference is likely to be that explicit consent must be affirmed in a clear statement, whether oral or written. Since for our purposes, most likely our consent is being gathered online via some sort of a written statement anyway. In practice, they're likely to look very, very similar in most cases. So that brings us to transparency. How do we meet our transparency obligations? The GDPR sets out very specific information that you should be supplying to individuals about your data processing, and it also tells you when you should inform them. So in most cases, this will be done through your privacy notice, also known as privacy policy or privacy information. All of these terms refer to the information about why you need people's personal data, what you plan to do with it, how long you're going to hold on to it, and if you'll pass it on to anybody else. So it's important that you are kind of explaining what you're doing and that it's easy for your audience to understand what you plan to do with it so that there's no confusion about it and that the expectation is kind of there from the onset. So the information that you supply is determined to some extent by whether or not you directly obtained the personal data from the individual or whether you got it from somebody else. So we have a few resources on our website that help explain this really clearly. But for example, there's this table on our website that you can also access, which shows that, for example, if you have gotten information directly from the individual, you wouldn't need to tell them what personal data you've gathered or how you've gathered it, for example, because they will be the ones who've given it to you. But it tells you that you must also make sure that the information that you're supplying is concise, transparent, intelligible, and easily accessible, has to be written in clear and plain language. And if you are addressing it, for example, to children, it needs to be particularly so understandable by them, and it has to be provided free of charge. In terms of when you should be providing the information, so if you are collecting the data from the individual, then that notice should be provided at the time that the data was obtained. And if not, then shortly after you obtain the data. So we would consider a reasonable period to be, for example, a month. And if the data is being used to communicate with the individual, then we would say that the notice should be provided when you first have that communication take place. And at all following communication as well, it should be re-provided. And if you're envisioning disclosure to another recipient, then the notice should be provided before you disclose the data. So in terms of some helpful resources that we have on our website, so in addition to these tables that kind of lay out exactly what you need, we also have a template privacy notice generator that helps you create a bespoke privacy notice for your audience, customers, users, donors. We have sector-specific ones. So we have specifically one for charity and voluntary sector, and I'm happy to pop the link for that in the chat after. Hopefully you all already have privacy notices, but if you're interested, you can go and check that out. Hopefully makes your lives a bit easier. So now we can chat a little bit about individuals' rights and what the GDPR says about people's rights. So the GDPR sets out a number of individual rights and creates an obligation for organizations who are processing personal data. Sorry, I've just seen a question. So it's our ICO website is the one in response to your question. Sorry, it just came up on my screen. But I will post a link to the resources that I'm mentioning and the tools that I'm mentioning afterwards as well. So these rights are, there's an obligation on data controllers to make sure that they're upholding these rights that individuals have, and they're set out in Article 12 to 22 of the UK GDPR. It's worth noting that most of these are qualified rights, which means that they're not absolute. You don't always have to fulfill these rights. There will be circumstances and exemptions set out that will give you basically exemptions to not having to, for example, delete somebody's data or what have you. So we can go into that. The only one that is an absolute right, which we will also talk a little bit more about, is the right to object to direct marketing. So we will go into that a little bit further on. So first, so I want to talk about subject access. This is actually one of the areas that we receive the most complaints about is individuals not having their subject access request replied to or not being replied to in time. It is a bit of a sore point. So we always suggest that if you have your records management set up in a way that makes it easier for you to respond to people's subject access requests, then that will make life easier for you. First, let me explain where it's found. So Article 15 talks about individuals' right to obtain for free confirmation that their personal data is being processed, and if they would like a copy of that personal data, has to be provided to them. So this right exists so that individuals can have an awareness of and verify the lawfulness of their personal data that's being processed. So like I said, this is somewhere that a lot of organizations struggle, especially I think nowadays people are becoming more aware that they have this right, so they are exercising it, which is great, but it can be a bit of a burden for organizations to fulfill these requests in time. Generally, the clock starts ticking as soon as you've received the subject access request. It can be sent verbally or in writing. There's no set format it has to follow. The controller has 1 calendar month to respond. You can extend it if it's complex, but you still have to write back to them, to the requester, and let them know within that month that you plan to take the extension. You should obviously make sure that the person who has requested the information is the person that they say they are before you hand over any information to them. So verifying their identification, their ID. What was I saying about? Yes. So like I said, if you have the right processes in place, if you have the right information management system that allows you to easily extract personal information and potentially redact third-party information before you pass it on, that can make compliance with subject access requests much easier, especially in terms of kind of meeting that deadline. And so, like I said, there's exemptions set out to when you would have to respond to subject access requests. There's various exemptions set out in Schedules 2 to 4 of the Data Protection Act. But DUA, the Data Use and Access Act, which has recently come into force, has also attempted to make things a little bit easier. They've added a clause saying that organizations only need to do a quote, reasonable and proportionate search for information to respond to a subject access request. So if you have done that and you're unable to find the information, or it's not a reason, it won't be a reasonable or proportionate search for you to find that information, then you can refuse that request. But bearing in mind, if you do that, then the burden of proof is on you as the data controller to show why you were not able to do that and why it was not possible to fulfill the SAR with a reasonable and proportionate search. And you have to be able to kind of document and show that. So then we have rectification, erasure, and restriction. Just a quick overview of what those are. So the right to rectification is Article 16 as the right to have any inaccurate data amended without delay. And if you have incomplete data, for it to be completed by means, for example, of a supplementary statement. The right to erasure is also known as the right to be forgotten. It's the right to request deletion or removal of personal data where there's no compelling reason for continued storage. Again, this one is not an absolute right. There will be circumstances where the processing has to continue. And so that has to be tempered against the right that the individual has. And then they have the right to restriction is a bit different. It allows individuals to ask to restrict their processing in circumstances where erasure might not be appropriate. So this can often be like a time-limited one where they want their data retained for some other purpose, but they're disputing its accuracy. So they just restrict you from transferring it to somebody else, for example. So for all of these, the similar timescales apply as for the subject access requests. And again, you have the right to refuse them if they are manifestly unfounded or excessive. And one thing to note as well is for all of these, if you are a data controller and you have received a rectification, erasure, or restriction request that you think is valid, and you are planning to follow through with it, then you should also, if you have passed any information on to another organization, then it is your responsibility to pass on the rectification, erasure, or restriction request as well to that organization if it doesn't create disproportionate effect for you. So the other one is the objection to processing, which it gives individuals the right to ask organizations to stop processing their personal data. So like I said, this is an absolute right when it comes to direct marketing. But it's also, they can also object to their processing if you have, for example, used legitimate interest as the basis for your processing, or if it's if you had used public interest, public task, or scientific or historical research and statistical purposes as your legal basis. So if they have objected to their processing, it might not mean that you have to erase it. It may be that you can just put up a flag in your database saying that they have objected to this specific type of processing. And you may actually need to retain their data so that you remember that there's certain types of processing that they have objected to, particularly if it's around direct marketing. And if there is yes, of course, there's an exception as well to this. So if you are processing, for example, for the establishment, exercise, or defense of legal claims, then they cannot object to their processing of their data. So now we can talk a bit about direct marketing. So direct marketing in the data protection context does not just mean what we might generally think of it. It's more than just trying to sell a good or a service. It also covers activity promoting. So for purposes of charity, might be activity promoting your charity, your ideals, or your political opinions. And so so the concept of direct marketing does apply very, very much to not-for-profits and charities, even though it might not seem to. So it is worth remembering kind of what the requirements around that are. So not just data, so the Privacy and Electronic Communications Regulation requires organizations to have a person's consent to send them electronic direct marketing communications. And there has been a longstanding exemption to this called a soft opt-in, which has enabled mostly businesses to send electronic marketing messages to customers who have previously bought things from them. So they have been allowed to send them information about similar goods or products that they think they might be interested in, and that has been called the soft opt-in. So this was never really very easily usable by charities because it could only be used in relation to commercial transactions. So it really only applied to charities where, in very limited circumstances, for example, if somebody had bought something from an online shop, like merchandise that you were selling, or had attended a paid for event, then you would be able to use this. But recently, under the Data Use and Access Act, this has changed, and now there is a charitable purpose soft opt-in, which has been introduced, which enables charities to send marketing emails and texts to donors and supporters, where the purpose of that direct marketing is to further your charity's charitable purposes. And there are a few key requirements to use this, which I will go into. So to apply to apply to any personal data that you already hold, this means that you will need to show that when you collected the contact details from the individual, that you offered them a clear opt-out at that point of collection. And you have to know that the recipient has not previously opted out from receiving direct marketing. As I mentioned before, that right to object to direct marketing is an absolute right. So if they had opted out, then you cannot use this. And you have to provide that option to opt out in all future communications as well. So on our website, we have quite a bit of guidance. Some of the pages are still being updated to reflect these changes made by the Data Use and Access Act. So just keep that in mind when using it. It might seem like you can't use it, but actually you can. We are planning an update to our direct marketing and privacy and electronic communications guidance this spring, which feels like should be now, but it was snowing up here in Inverness, so I don't know when spring is coming. But we have a direct marketing advice generator as well on our website, which is a great tool to help you determine whether what you're doing is direct marketing, and then what requirements are you need to fulfill to kind of make it legal. And that tool as well, hopefully, will be live this spring, so hopefully in the next month or so, and that will hopefully make it easier to apply this as well. So just again to go over how to use that charitable purpose soft opt-in. If you are planning to use it, you should keep separate lists of people who have, for example, given their consent to use electronic mail marketing, and people who you will be using this charitable purpose soft opt-in. You may even want to keep a separate list again for people who have given you, who have bought things from you previously, and so you're using that commercial soft opt-in. You may well need to have a conversation internally around making sure everybody understands what the differences are, so that then you are also able to explain this if you are contacted by individuals asking them, why are you sending me this email, or why are you writing to me? There is just a few different routes to now, I guess, use direct marketing, so you should just have your ducks in a row from that point of view if you're planning to use it. So quickly, I'll now go over data breaches. So a personal data breach under data protection legislation is a breach of security leading to accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. So it's actually a wider sort of set of circumstances than you might initially think when you think of a breach, which can seem like a very specific kind of cybersecurity thing. But it can be something that has nothing to do with a technical system. For example, it might be accidentally sending an email that was meant to go to one person to another that contained another person's personal information, for example. It might be a failure to redact somebody's personal data, a third party's personal data, when you fulfilled a subject access request, for example. So all of these things would be considered a breach. There's an obligation on all organizations to report certain types of personal data breaches to the ICO within 72 hours. And these are when there is likely a risk to the rights and freedoms of individuals. And it's up to the data controllers to determine whether that threshold is met for requiring that notification. And as I mentioned earlier, if you're a processor, then your responsibility is to quickly notify without undue delay your data controller to let them know that this has happened. If you've confirmed that there has been some sort of a personal data breach in your organization and that the breach has resulted in an adverse risk to the rights and freedoms of living individuals, as soon as you've made that assessment, the clock starts ticking, and then it's your responsibility to make that notification. And if that breach is likely to have resulted in a high risk of adversely affecting individuals' rights and freedoms, you must then also inform those individuals without undue delay so that they can take any precautionary steps to protect themselves or deal with the fallout from that breach. So to make that possible, it's really important to have robust breach detection, investigation, and internal reporting procedures in place so that if something like that happens, you're able to act pretty quickly. And you also have to keep a record of any personal data breaches, regardless of whether you decide you needed to notify. So another resource that the Information Commissioner's Office website has is a self-assessment tool for data breaches. So if you have had a data breach or you think it might be a data breach, we have a tool that helps you make an assessment of whether A, it qualifies as a data breach, and then B, whether it's one that requires a notification to the ICO or to individuals as well. That is pretty much all I wanted to kind of go over. There are other resources as well on our SME hub that we would invite you to come and take a look at. And one thing I just wanted to say, there are a lot of resources currently on our website that are still being updated. So there will be a little health warning on the top saying that these pages are still to be updated because of Data Use and Access Act having come into force, but there is also a timeline of when that will happen, all available on our website. But for the most part, a lot of what I've covered here hasn't changed, so those resources should still be usable. I had received some questions in advance, so I'm going to quickly try and address some of them, and then we can maybe go to the questions that have come into the chat if you think that makes sense, Claire. Shall I tackle those ones initially?
Yes, that would be great if you could do that, yes.
Okay, so we had, somebody had asked about paying an exemption to paying the data protection, the ICO fee. So generally speaking, most data controllers have to pay a fee, but there are exemptions. You don't need to pay a fee if you are only processing data for staff administration, advertising, marketing, and public relations, accounts and records, not for profit purposes. So again, that will apply to many people here, personal, family, or household affairs, maintaining a public register or judicial functions. We have on our website registration self-assessment. So if you are not sure, you can go on there and check to see whether you do need to pay the data protection fee. But yes, we always say, even if you don't need to pay the fee, you still need to comply with all of the other data protection obligations. The other question we received was around whether all trustees of a charity should have access to full personal details of all members. Should that be limited to, say, officers or a need-to-know basis? Definitely, we would say a need-to-know basis. You want to make sure that you are only allowing data to be accessed by the people that need to be able to access it, and always having that necessity and proportionality and security kind of at the back of your mind. So if all trustees of a charity do not need access to all of the information, then there should definitely be access controls built in. I'm not sure if that was specific enough, or if there's a very specific context that that question was trying to get at, I'm happy for that to be clarified, and then we can go into that. There is one more question, which was around kind of the proliferation or the movement towards citizen-held data, and how we think that that might affect how people have to do data protection compliance, and what regulatory risk that might result in. So I understood that to mean that we're talking about, for example, apps and stuff that allow people to hold their data within it, and basically moving towards data following the user rather than being held by a bunch of different organizations. Our general response to that would be that it's really about following where the data flows are going and figuring out who the controller is. Because if there is an app, for example, or a platform that is holding that data, it is still, we would say, the controller, and therefore the responsibilities are unlikely to change. It's, it might be that the data protection impact assessments have to factor in what the impacts might be of, letting an individual have all of their data downloadable on your platform. But in terms of the controllership relationship, there really shouldn't be a huge change from the kind of compliance perspective. And yeah, if anything, I think there might be it might be worth looking at the outcomes that might affect you as a data controller if, for example, the individual loses the data or asks you to delete it. Do you need to have it re-accessible? What are the possible consequences? So I think those are things that are definitely worth risk assessing. But in terms of the controller processor relationships, I don't think things should change. We don't think things should change from the compliance perspective to a great extent. Claire, do you want to bring up, I don't know, I've actually not had a chance to look at the Q&A to see if we've had other questions.
Yeah, so there's a few questions in both the Q&A and the chat. One of the questions is what qualifies as large-scale processing? You'd mentioned that there was a requirement for a data protection officer if it's large-scale special category data, but what would quantify large-scale data?
That is a very good question. So basically, if you are doing, so there's no explicit definition for that, but if you're not doing it as a one-off, for example, and if it's not, like an individual number of times, if there's factoring in large volumes of data, if it's factoring the number of individuals that might be affected, how long you're doing it for, is it a one-off or is it something that you're going to be doing repeatedly? We would consider, for example, how many people might be affected. So these are all things that would be factored into whether what you're doing is large scale. We actually have guidance on this as well on our website, which I can try and pop a link into how to make that assessment.
That's great, thank you. The next I have is, and there's two questions actually around individual data. So do you need a separate privacy notice for children, and do we need individual data protection policies for staff, volunteers and trustees?
Yeah, so I think if you are targeting children and you think that the privacy notice that you have done previously is not going to be easily understood by them, then I would say yes, that would be a wise thing to do. In terms of all of those different stakeholders that you're engaging with, if you are using their data in different ways and there's different data processing activities, then yes, they would probably need different privacy notices, because the privacy notice has to be very specific in telling the individuals exactly what you're doing, what data you're processing, how you're processing it, who else you're sharing it with. So if all of those answers are different for each of those groups of people, then you would need the privacy notices to reflect that.
Okay, thank you. And then we have a question about membership subscription schemes. So if they have a membership subscription scheme and one of the members dies, does the info have to be deleted immediately, or are they required to retain it for a certain period?
So first of all, that would then fall out of scope of the GDPR because the member is no longer living. So the personal data that they hold is no longer relating to a living person. So I think that would be more relating to their own personal policies on what they want to do with the data that they have, but it wouldn't necessarily have bearing on the privacy compliance side of things.
Okay. Another one around museums collections. Do you have any advice on retention of personal data of people who have donated items to our collection? Is this exempt from GDPR or covered by GDPR? So they hold names and addresses and identifiable information around people who they've collected museum donations from.
Yeah, so that would be something, for example, that you could now use the charitable soft opt-in, charitable purposes soft opt-in for. So like I said, making sure that you have given them the chance to opt out. So if people have donated to you, whether it's items or donated money to you, now charities are able to use that previous contact as an opportunity to ask them to support them in other ways for other campaigns or what have you, as long as they have fulfilled those other requirements that I mentioned around giving them the opportunity to opt out.
Okay. In, I'll try and just maybe cover off just one or two more because I know we're coming to the and we can pick up any more after the event when we share the recording. We'll share a Q&A as well. But this one is a common issue that arises when emails are sent to a number of unrelated individuals who are copied in rather than being blind, so that everyone on the distribution list can see their email addresses. Asking if that constitutes a breach and what would be a proportionate response to that if it is a breach.
Yeah, so I think it absolutely could be a breach. So if everybody's email addresses, for example, are visible, it may well be that is actually very likely that you are able to identify individuals from their email addresses. And there may be consequences to those people, especially depending on the content of your email. For example, if you are a cancer charity and you are sending an email about, the specific type of cancer that these people have, or this is a group of patients who have previously asked to access some sort of a counseling service. These are all special categories of data. So it is, elevates the level of seriousness of that breach. And so you've allowed the other people on that list to see who else is on that list. So that would absolutely potentially be a breach depending on what's in the email.
And I think we'll probably just have time for just one more. And the one that's at the top of my list is how long is a reasonable time to keep personal data for a volunteer if they're dormant? So is there a minimum time or is it organisation led? So I think this is where somebody's been volunteering, but they've maybe not volunteered for a while. And how long should you hold that data?
Yeah, so we don't give specific time periods of what would be considered appropriate. I think there would be a lot of factors to consider, like how likely do you think they are to be a relevant volunteer to have on your database after a certain amount of time. You might look at how other volunteers' trajectories have gone, for example, to make that decision. You might look at whether you have tried to reach out to them in the past, whether they have had other engagements, but that would come down to basically an organization to make that assessment based on the kinds of volunteers that they have and the kinds of things that they're engaging with that charity with, for example. But yes, it would be basically assessing the necessity and proportionality of retaining their data for extended periods of time.
Thank you. That's really helpful. I think that's probably all we have time for today. And again, I difficulties at the start, so thank you all for bearing with us and joining on to the second link. And thank you, Sana, for the presentation. That's been really helpful. We'll share the presentation on our website and YouTube channels. We'll share the Q&A from the session at that time as well. So if you have asked a question that we've not been able to answer, we'll make sure that that's covered in our Q&A. So thanks again all for attending. keep you updated on any future events. Thank you.
Thanks so much, everyone. Bye-bye.
Thank you.